All right, welcome back, everybody, to our fourth and what I believe will be our final segment for today's asynchronous class. So, just by way of review, in terms of the definition of agency, we may want to ask ourselves for a second: why are we so focused on control? Remember, that was what so much of the Warren and Cargill case was about. So, we're focused on control because if we can demonstrate control, we meet the second prong of the definition of agency. Remember, the definition is acting on another's behalf and subject to their control. So, was there control in the case of Cargill? Yes, there was control. But when we do that, when we focus on control, that presents what might be a puzzle for us based on some other cases that we've read in our discussion of fiduciary relationships. So let me just play out the puzzle for a second, and we can discuss it in class if this is something you find of interest. So here's the puzzle. We're focusing on whether the principal exercises control of the agent to determine whether we have an agency relationship, right? That much should be clear. That was the clear implication of the last two cases, and especially the Cargill case. However, in our discussion of when fiduciary duties arise, what did we say about control, right? We said that fiduciary duties arise when the fiduciary exercises control over the principal, right? So we said that a lawyer has control over the client. A doctor has a kind of control over the patient. A trustee has control over trust assets. And we said as a result of that control, the principal is in a more vulnerable state, often relies on the fiduciary, the agent. And so we said that's a reason why we will impose fiduciary relationships. But now we're looking for control by the principal over the agent to prove that an agency relationship and therefore a fiduciary relationship exists. But I thought a minute ago we said, wait, it's the agent who is exercising control, and therefore we want to place a fiduciary duty on the agent, on the doctor, on the lawyer, on the trustee. So how is the agency relationship and the control test consistent with the fiduciary theories that we've been discussing over the past weeks, right? That's really the puzzle. That's the question. We were focused very much on control by the fiduciary, by the agent over the principal to determine whether a fiduciary relationship exists. Now, all of a sudden, we're turning that on its head and we're saying we have to find control by the principal over the agent in order to find that an agency relationship and therefore a fiduciary relationship exists. So which is it, right? How can they both be true? That's the puzzle. It's fun to think about. And if you want, we can take it up in class and talk about it in person. Last case under agency is the Hodison case, Hodison versus Coos Brothers, which I give you guys because it's kind of a fun case to think about and does teach some important lessons that are related to agency. So the plaintiff in this case, Mrs. Hodison, went to Coos Brothers Furniture in Rahway and met up with a salesman, this was a long time ago, who took her order for $168 in furniture. She did what people did back then. She gave him cash, right? Sounds very odd to us. We would never do that today, right? But that's the way things were done at the time. Unfortunately, she got no proof of payment. Right, so she did give cash over, and then she was going to get the furniture at a later date because they didn't have everything she wanted at the time. But she got no proof of payment. When the promised furniture never arrived, she followed up with Coos Brothers, and she learned that the store, to her dismay, had no record of her purchase whatsoever. Right? She sues. She says that she wants the furniture, right, or wants her money back. She sues and she won in the lower court, but the store appeals, even though it was only $168, because it's very concerned about the kind of precedent this would set. Mrs. Hodison, in fact, was unable to identify which salesman was hers out of a lineup, and the one possible person who she thought it might be was actually on vacation at the time that she made the purchase, so couldn't be him. So she's unable to identify who it is. Coos Brothers insists at trial that they are not responsible because this salesman was effectively an imposter, right? He came in, pretended to be a salesman, and basically stole her money. And this was possible because Coos Brothers had many salesmen, all working on commission, and it wouldn't be surprising to see somebody walking around with a notepad and a pen and talking to customers. The lower court disagrees and rules in Mrs. Hodison's favor because it believed that the person who took the money was effectively an employee, right? Was acting as an employee. Coos Brothers says there's no evidence of that, right? None whatsoever. And the question then here is whether agency was established through a doctrine called apparent agency, right? Apparent agency. So on page 706, the court distinguishes among express agency or express authority, implied agency or implied authority, and apparent agency or apparent authority. And the question is, what's the difference, right? And you can pick this up from the case if you read it carefully. Normally, in an agency relationship, a principal gives express or implied authority to an agent to act on the principal's behalf, right? I tell my assistant to go out and hire a new head of IT. My assistant then has hiring authority to go out and hire that person, and I've given them express authority to do it. And they have implied authority to say, set the person's salary and decide on an amount of vacation because I've told my assistant to go ahead and hire somebody. And so they have express authority to hire and implied authority to set the terms of employment. That's just an example. In apparent agency, it's a little bit different, right? In the case of apparent agency, a principal says to a third party, not to the agent, says to a third person, a third party, that someone else, the agent, is essentially acting on my behalf, on the principal's behalf. So the communication is not to the agent directly, saying you have authority to go out and hire. It's communication to the outside world, maybe somebody who wants the job. My communication to that person is, don't talk to me about that. Talk to my assistant who I've given authority to hire, right? So the key is it's a communication between the principal and a third party. And the idea is similar to the old doctrine of estoppel, right? If a principal tells a third person that an agent is working for the principal, then the principal is later estopped from saying that the agent could not enter into contracts on the principal's behalf, right? The idea is that the principal held out this agent as acting on the principal's behalf, gave the appearance, hence the title apparent agency, gave the appearance that that agent was acting on the principal's behalf by a communication from the principal to third parties out there. Don't talk to me about the job. I've delegated that to my assistant. Talk to my assistant, right? I've given that appearance that my assistant has authority to go out and hire. The idea of estoppel, the court says, operates to allow recovery in this case. We can call it apparent of agency, which is why it's an agency case. We can call it agency by estoppel, or we can call it something like tortious dereliction of duty, because the whole idea is the same. The duty of care that the Coos Brothers store had means more than just physical safety, right? It just means more than making sure that the floors aren't slippery and wet. It includes protecting customers from deceptions by an apparent salesman, right? So the duty of care means more than physical safety. It also includes protecting customers from being deceived by somebody who is pretending to be a salesman. If the appearance of someone as an agent leads a customer to believe that that person really is an agent, and the customer in fact transacts with that person, then the proprietor cannot simply claim a lack of authority and escape liability. Let me just say that quickly again. If the appearance of someone as an agent leads the customer to believe that he or she really is an agent, and the customer actually transacts with them, then the proprietor, the owner, the principal, cannot later claim a lack of authority and escape liability. So that's the case, right? You can call the doctrine in this case apparent agency. You can call it estoppel. You can even call it, as I say, tortious dereliction of duty. But either way, there is liability under this case and based on agency principles. But it's apparent agency and not express or implied agency, which is the normal kind of agency that we would expect to see. All right, that's it. That's the last agency case. When we pick up on Wednesday, we'll talk about the second set of agency cases. We'll do it in person, and I look forward to seeing you then.